Yes, that would be great. Thank you so much. Great. Thank you. Good afternoon. Thank you very much, Attila, for inviting me. This is a topic that has been around for quite a while and is gaining interest in ever-widening circles. I'm going to talk about, ultimately, the interaction between domestic violence as a general issue and the criminal justice system, which is a very specific mechanism for responding to incidents of domestic violence. Now, I will preview my remarks by telling you that I anticipate that some of what I will have to say may not please you. You may not like to hear what I have to say, and you can disagree with it, but there are some things out there that simply have to be accepted before we move forward with anything resembling an intelligent discussion in the topic. I love fables. I think they're some of the greatest literature on earth because even though they're interesting stories, they teach a wider lesson. And one of my favorite fables, it's actually a joke, and you don't normally start with a joke, but in this case I thought it might be appropriate, is that Sherlock Holmes and Dr. Watson go camping. And at about 3 a.m, Watson feels a sharp poke from an elbow into his ribs, and he wakes up, and it's Sherlock Holmes who did that, and he says, "Holmes, what's the matter?" And Holmes says, "Look up." And Watson looks up. He says, "What do you see?" And Watson says, "Well, I see a whole bunch of lights." He says, "That's right. And what does that tell you?" He says, "Well, I know that all those lights are stars, and I know that our solar system, of course, our sun is a star, and there are planets, and I know that there are billions and billions of stars that we can't even see, and so there are umpteen billions of planets. And the laws of probability tell me that at least one of those planets has sentient life on it. So no matter how alone or vulnerable or weak I feel, I know that there's sentient life out there, and that gives me some comfort and a certain level of inner peace. What does it tell you, Holmes?" And Holmes says, "Well, it tells me somebody's stolen our tent." So, my point is that perspective is really important in this particular case, because what I've been called on to discuss, and what my good friend and colleague Walter Fox will also be discussing, is the criminal justice system. And the criminal justice system is this thing. It's this living, breathing thing that hums along 24 hours a day, each and every day, just waiting for somebody to plug in. And there's an infinite number of plugs, but once you're in, it's very difficult to unplug, particularly if you find yourself on the wrong end of a criminal charge, because what then happens is you have to deal with being released, usually on bail in the case of domestic violence, and I'll get to that. Then you have to hire a lawyer, and lawyers cost money for a good reason. There's a limited supply of good skills in the area. It's supply and demand. And if you go in by yourself to the criminal justice system, the likeliest outcome is you'll come out with an administrative record. Maybe not a full criminal record, but your chances of actually being acquitted are close to zero. And they will do everything they can, and I'll have more to say about that. They'll do everything they can to persuade the accused to take responsibility for what happened without, they assume that the accusation is true, and you've got to remember that. So, perspective. Here are some realities. There are men who abuse their partners, physically, emotionally, and sexually. There are women who abuse their partners the same way. And there are men and women who do the same to their children. How many are there? I have no idea. And neither do the people who put up these numbers. They have no real idea what's going on out there. But they come up with, well, only 3% are reported. How do you know? How do you prove a negative? It's very hard for me, as a defense lawyer, who is trained in moving through a process based on reason, evidence, and principle, to listen to this nonsense and watch, and it's painful to watch it being accepted lock, stock, and barrel. It's just swallowed whole and accepted as gospel truth, despite the absence of any evidence. So now, our hypothetical accused, and yes, we'll make him a man, we'll make the accused a male, because, as was pointed out earlier, the likeliest profile for someone accused of domestic violence is a man. Well, what's probably happened? The relationship partner, usually a woman, calls the police. I've been hit, I've been struck, I've been pushed, I've been punched, I've been kicked, I'm in the hospital, I'm afraid for my life, this and that. The police show up, and their default position is the man's going to get arrested and thrown out of his house until he takes responsibility. For what? We don't know, but he's going to take responsibility for it to get back in. The first thing that creates, from a defense point of view, is a definite risk that he's going to take responsibility for something he did not do, just so that he can get back with his family, stop paying rent on 2 places, get his life back in order, and oh, by the way, you'd be surprised how many times the person who called the police says, wait a minute, I didn't know you were going to take him away. I just want you to talk to him. Well, too late, lady. Why? Because the police officer who doesn't arrest may be facing disciplinary charges. And, going back to the issue of perspective, if something happened, the one thing you don't want is they come and they say, okay, well, just calm down, don't worry about it, and 3 hours later there's a call on a homicide at the same address. They don't want to take that risk, and they always operate on the worst-case scenario. As soon as the arrest is made, there's a victim, from a legal standpoint. Who's the victim? Whoever called the police and says I was assaulted. The problem with that is we can speak about victims all we like in the ordinary understanding of victim. The problem is that when you talk about it in the context of the criminal justice system, that becomes a completely inappropriate characterization of the complainant. Legal proceedings have titles. Party A against Party B. So in a slip and fall, it's Jones against Smith. In a divorce, it's Smith against Smith. Every criminal proceeding is titled the same. Her Majesty the Queen against whoever's been charged. When Her Majesty moves on to better things, and if her replacement is a male, it'll be His Majesty the King. That, all of them. The victim in every single crime committed in Canada is you and me. Right now, as crimes are being committed, we are the victims. We are the community. And we are represented by Her Majesty the Queen and her council. There's a long historical reason for that. Bottom line is that at some point, about 1,000 years ago, the British monarchy decided to stop letting people settle their own differences. You don't get to burn down each other's castles anymore. You don't get to have trial by champion anymore. You have a third party, the state, who has no interest other than justice and the application of legal principle, deciding the outcome. But that's not what's happened. What's happened is we have adopted a victim-based theory of criminal law. And so, woe is me, the poor victim. And that creates sympathy. That creates a paternalistic, in this case, attitude that women need to be protected because they are the victim or victims of the inherent evil and violent tendencies of men. They need protection. They are not the victim in a legal sense. They are the complainant, and they are nothing more and nothing less than witnesses. I can tell you that any defense lawyer worth his or her salt will have the exact same attitude. I don't care who's up there testifying. I care that they're testifying against my client, and I'm going to test that person's evidence with every fiber of my being if the thing goes to trial. I have no sympathy for them. They're a witness. The victim is Her Majesty the Queen. That's my opponent. That's where I focus my energy. I'm there to protect my client and nothing else. But that's not how the public sees it. The public sees the victim as the person who says, I was assaulted. They keep crying. These so-called victims' rights groups keep crying about inadequate resources. We need more resources. We need to be protected. Nobody cares about us. You're damn right nobody cares about you, not from my side. I shouldn't. As soon as I start caring about them within the scope of my job, I have to stop doing what I'm doing. Will I knowingly abuse somebody in the witness box? No, because the rules of professional conduct don't allow me to do it. I have responsibilities as an officer of the court. I like to think that I wouldn't do it anyway, but, self-delusion is what it is. So there are limits as to what I can do. But they cry about a lack of resources. So let's take a look at what's out there. Police officers, victim witness assistant programs, VWAP. I wish they would rename it what it should be, which is complainant witness assistant program. But then the acronym would be QWAP, which is not what I think, it's not the image that I think they want to project. So we have VWAP. We have crowns. We have secondary police officers. We have counselors. We have judges and courts who are trained to be incredibly sensitive to the feelings of the so-called victim. It's one thing to say, I'm going to be polite, I'm going to be nice, I'm going to try to avoid making you feel bad about yourself. Got it. I'm in. I was brought up well, I think. But it's quite another to say, the information before the court is that on or about the 14th day of May, 2014, Tom Smith did commit an assault on Jane Smith, contrary to the criminal code. Poor Jane Smith. I really, really need to be careful here. And she really must be here for a reason. And you'd be surprised how many times I walk into court and I know that that's what I'm facing. I'm facing two crowns. The one who's actually prosecuting the case and the judge up there who, while may not have decided the case already, is definitely sympathetic towards the Crown's case. And we haven't said a word yet. That's what they're taught to do. They're taught to keep an open mind, but it's also very difficult. Again, we go back to perspective. Imagine that if what you did for a living involved being lied to each and every day. Every day. Every criminal trial contains lies. Every one of them. It's just a matter of who's lying. There wouldn't be a trial if everybody was telling the truth because you'd know what happened. So, if you sit up there with your red sash and you're being lied to every day, you're going to change. And if you think that the person likeliest to be lying is the defense, that's going to affect the way you do things. So, our hypothetical accused has been arrested. He's held for bail. Bail. Why? The default position has become surety bail. Somebody signs for the accused, promises to pay a certain amount of money if the accused doesn't follow the conditions of bail. And it's a residential bail. The accused has to live with his surety. stay away from the complainant, not be within X meters of where the complainant lives, works, or is reasonably expected to be. But the default position, as a matter of legal principle, used to be you let the accused go on his own recognizance. Not anymore. Bail. Why? The reason I suggest is institutionalized feminism within the criminal justice system. They just managed to grab a hold of this thing, take control of the public debate, define the terms of the discussion, and say that there's only one acceptable outcome. The problem is that the informational foundation for all of that is quickly becoming exposed as bunk. A couple of years ago, sometime in the last couple of years, there was an issue in the Supreme Court of Canada about whether the accused had been charged with a sexual assault. The complainant was developmentally challenged, severely so. She was 26, but operating at the level of a 4 or 6 or 7-year-old. Well, the first thing a witness is supposed to do is either take an oath to tell the truth or affirm to tell the truth. If you're a child, if the witness is a child, then they're asked to promise to tell the truth. This witness didn't know the difference between telling the truth and lying. The judge made the inquiry. And the judge said, well, if the witness doesn't know the difference between the truth and a lie, how am I supposed to know the difference? I can't accept that witness's evidence, and dismissed the charge. Worked its way all the way to the Supreme Court of Canada, and in its opening paragraph, or paragraphs, Supreme Court of Canada says 25% of people, 25% of developmentally delayed individuals will be, or no, it's more. I thought they said maybe 75. It was a very high number. Even 25% is very high. Will be sexually abused. They found that as a fact. And as soon as I read that, I knew what it was going to say at the end of the judgment, which is that this witness's evidence should be received, because you can't risk having developmentally delayed people exposed to the risk of physical and sexual abuse. Turns out, though, that the factual foundation of that was a study that had been done, 40 years earlier, 35 years earlier, no peer review, unscientific method, a ridiculous piece of junk term paper written by some PhD or master's candidate. But the Supreme Court of Canada accepts it as gospel. Why? I think it's because people are afraid to tell the truth. People are afraid to, as they used to say, speak truth to power. I mean, there's a lot at stake here. There are people whose entire lives, mortgages, pension plans, careers, are heavily invested in maintaining this attitude in the criminal justice system. So now our accused has been released on bail. He follows his bail, has to go to court 5 or 6 times before even a trial date is set, and then has to wait, at the best of times, between 6 and 8 months for a trial, maybe as long as 2 years. Here's the problem, and it happens a lot more often than you think. The stress of going through that drives a lot of people over the edge. Financial, emotional, the physical toll of being separated from your family, from your children. There's also, and again, this, I don't know what anybody else's experience is, but I've seen it too many times to just say it's coincidence, that the accused is involved in matrimonial litigation. I had a client who got arrested for breach of bail 4 times. 4. What did those 4 occasions have in common? They were 2 days before the next court appearance on his matrimonial. What were they fighting over? Custody, access, and support. So, there's nothing anyone can do in 48 hours. Nothing. You can't line up sureties and have a bail hearing, and you can't. So, those 4 adjournments sucked up about a year and a half. Got arrested, got charged. I went to trial with them, and at the end of the trial, the judge basically said that he didn't believe the evidence of the complainant. He simply didn't. It was completely incredible. She would have been more credible had she said that my client had kidnapped her and taken her to Pluto. I'm not talking about the dog at Disney World. I mean the planet. That would have been more credible than the story that she gave. But the police, well, we have a policy, no tolerance, zero tolerance. So now our accused is on bail. Our accused has hired a lawyer with experience, a lawyer who is fearless, a lawyer who knows the courts and legal principles. Yes, you, Walter. And is now mortgaging his children's future because he has to stay out of jail. He has to avoid a criminal record. And oh, by the way, he's innocent. He's presumed innocent, and he wants to fight. People charged with domestic violence today are no longer required to attend at court at 9 in the morning. That used to be the case, not anymore. 1 o'clock in the afternoon. Why? Because at 1 o'clock, you get a presentation, half an hour, on why you should take responsibility for what you did. You'll be offered diversion. You'll be offered a discharge. You won't have a criminal record. You'll be back with your family as soon as, so fast, and this will be a dim memory, and you're a good person. You just made a mistake. Don't worry about it. Here, come here, just sign here, and we'll get you out of here. Of the half-hour presentation, they might spend 3 minutes on why they might want to consider hiring a lawyer and defending the charges. That's the system. In one courthouse, there is a woman literally trolling the hallways, looking for people, because she's got the list, charged with domestic assault, and hustling them away from the courtroom before they have a chance to appear and say, hang on a second, can I come back in a couple of weeks? I want to hire a lawyer. That's the system. So now a hypothetical accused has paid his lawyer, has waited it out, and has his trial. Shows up on the first day of trial, ready to go. I got my witnesses, I've got my lawyer's fully paid up. Not guilty, I'm ready. Complainant's not there. Well, what should happen? Where's the complainant? We don't know. You'd think that one of the realistic possibilities is, you know what, if she can't be bothered to be here, we're going to withdraw. Nope. Adjourn. One of my clients was charged with a sexual assault. That made no sense. None. We adjourned 4 trial dates. Well, I'm not as generous as Walter is with his clients. If my trial doesn't go ahead on the day of, I'm sorry about that, but I need more money. I'm not a registered charity. So now our hypothetical accused has to dig deeper into an increasingly empty pocket and put up with all the rest of the nonsense and come back 2 times, 3 times, 4 times, until the Crown, in its generosity, says, oh, well, that's the way it goes. Goodbye. We'll withdraw. Why not the first time? And you'd be surprised how many times the Crown will simply not look at the disclosure, not look at the investigative notes. They look at the first 2 pages, which is a typed summary called a synopsis, which puts the case of the Crown on its best footing, and say, well, this is our case. We assess it based on the synopsis. The guy must be guilty. And away we go. Everyone forgets, or it's almost everyone forgets, that there are real human beings here. And I include the complainant in that. But the accused is the one who's on trial, not the complainant. So when people scream about so-called victims' rights, they have none. They shouldn't have a single solitary right in that process. The accused has all the rights. The accused is presumed innocent. The accused is on trial, and it is the accused who is facing a deprivation of liberty, not the complainant, because I cannot recall the last time that a complainant who was found to be completely lacking in credibility was charged with perjury or public mischief, which is a very serious charge. It's leading the police on a false investigation, among other things. Why aren't they charged? Well, we're going to discourage. If we do that, people are going to be afraid to report. Well, yeah, they should be. If you're going to lie to the police and cause another human being to go to jail, you should be very afraid for yourself and for your liberty. But there isn't any incentive. None. And as was pointed out, this affects men primarily. Things are changing. Slowly, in painfully small increments, but they're changing. And they're changing because people are finally starting to realize that maybe we need some balance. I didn't know this until very recently, and a friend of mine told me about this. There are hundreds of PARS programs for men across Canada. PARS is Partner Abuse Responsibility something or other. It's where they send accused to undergo partner abuse counseling and rehab and domestic violence and coping mechanisms and so on and so forth, become a better human being, don't abuse your relationship partner. I think that's a great idea. I really and truly do. How many PARS programs are there for women who commit acts of violence against their partners in Canada? None. Not one. 34 million people in this country, half of whom presumably or close are women. Not one program. Why? Because we're caught up in this mindset that men are inherently evil. Women need protection. That's paternalistic. It's sexist. But even after you move through and past all those adjectives, it is also a dereliction of responsibility. It is a denial of reality that men suffer at the hands of their female partners. I had a client 20 years ago, and it's how I met one of my very good friends in this business. My client was 5'8", weighed about 140 pounds, 150 pounds, decent shape, but not great. His wife was 5'10", 215 pounds of muscle. She was not an overeater. He comes home one night, late. She thinks he's been cheating. Where have you been? I was out with the boys. No, you weren't. And they get into it. The argument escalates, and what she does, I don't know if you remember commercials for something called Vision cookware. It was this yellow glass cookware that could withstand high temperatures. And the reason it could withstand high temperatures is that the bottom, among other things, was very thick, and it was a heavy pot. She picks up one of these things and swings it at him. The only thing that saved his head from being split in two is that he raised his left arm, which she broke in two places. They both got charged. The police come, there's not a scratch on her. But they arrest both of them. And I'm still convinced that the only reason they did that is because they could see his arm dangling and broken. By the way, they were both very good people. But things happen. But the attitude of the institutional forces, the police, is there's no way the guy's walking away from this. It's just not going to happen. So, sentencing is all over the map, but it's getting better. The accused, mostly men, aren't automatically facing jail. In fact, the government is so intent on keeping up its numbers of people who are recorded as having taken responsibility in one fashion or another, whether it's guilty plea or diversion, but taking responsibility and going through counseling, that they're giving away the store in some cases. Sure, you want to take counseling? Absolutely. We'll just put this over, we'll get you a discharge. 5 years ago, a discharge was a pipe dream. You weren't going to get it. You do now. The people with whom I work in the criminal justice system, the Crowns, are great people. They really are. They're dedicated, they work hard, they're smart, but like seemingly the rest of the community at large, they're trapped in this mindset, and they have policies to follow. And again, going back to perspective, you have to remember, no matter what your political views are, that Crowns have mortgages and families and futures to attend to, just like you. Yes, they have a theoretical legal responsibility to see that justice is done, but they're people. I'm people too. I come at it from the zeal of a defense lawyer. So I come in sometimes and I say to myself, oh, this person must be lying. It happens. It's a human process. But it's getting better at a pace that some people don't like. It's too slow. Other people don't like it because it's too much. There's no way. We have to wipe out the scourge of domestic violence. It's not going to happen. People are going to beat on each other as long as there are people. That's not the issue. The issue is risk management, not risk elimination. So what's the answer? I have no idea. The answer isn't the legal one. It cannot be within the legal system. Because if we want to make a point through the legal system, each and every one of us has to go out and commit a crime and show the legal system that it's not treating us properly. Well, that's clearly not practical. The answer is gatherings like this. You discuss the topic reasonably, not ideologically. They're not going to listen to you. They don't care. Why? Because they're in positions of power. They don't feel threatened. Oh, you're a men's rights group? Great. If you put all your money together, plus the men's rights you think you have, you still can't find coffee in Toronto. So we don't care. We own the politicians. We own the policymakers, the wonks in the government who decide which way the wind is going to blow tomorrow. We determine who the judges are in the courts, and no matter how well-meaning they are, we're going to keep the pressure on them to have our point of view, that men are evil and women need protection. The answer is to get involved, I think. The answer is to talk about it consistently, persistently, and reasonably. You can't appear to be a fanatic. Nobody's going to listen. Nobody's going to listen. You have to push, and refuse to give up. And sooner or later, something will break in your favor. It has to, because the other side inherently makes no sense. And I make a living doing this kind of work because clients come in and say, I didn't do anything. Why am I here? And I have no alternative but to say, and they say, I want to go home. And I say, well, You want to go home tomorrow? Oh, yeah, great. Plead guilty, but I didn't do anything. Well, then let's go. The answer is not in the justice system. I can tell you that for a fact.